So good afternoon. I would like to welcome everyone to our webinar. This is our second webinar from the City of Sacramento on our Tenant Protection Program. So again, this is one of several webinars that we're going to be having as we fully implement the program. Our first webinar was a little bit more focused on landlords and tenants. This webinar is going to be a little bit more focused on, on landlords. This webinar is going to be a little bit more focused on tenants. However, as always, anyone's invited to participate in our webinars, and we'll answer questions from both tenants and landlords. So again, we are going to be recording this, and it'll be available on the TPP website. If you missed our first webinar, that has already been posted to our website. So I'm going to go ahead and start the presentation. I have a PowerPoint that I'm going to go ahead and show everyone. So again, thank you and welcome. This is about our Tenant Protection Program. So this is just an agenda, and I keep forgetting to change the date on this thing. It's actually for today, the 30th. This year we have panel introductions. We're going to have an overview with our Tenant Protection Program and the Sacramento Self-Help Housing Program. We're going to focus and talk about tenant assistance and give some information on what tenants can do if they need assistance and how to contact our office. And then in the end, we'll have question and answer. So we're going to ask that you use the Q&A feature in Zoom when you ask questions. That's better than using the feature for chat. We won't be monitoring the chat. Questions are going to be answered again at the end of our presentation. And anything that's similar or repeat question, we're going to go ahead and summarize for a response. So if we see a question that it's the same or it's repeated, we'll just summarize that question and answer it at one time. So if you have a specific question for your circumstance, it would probably be best that you go ahead and send an email to us at tpp@cityofsacramento.org. And the reason why we say that is sometimes we need to dig a little deeper. So we want to make sure that we're getting all the information that we really need to answer and address your question. So we need to get into the weeds, and also we don't want to have all your business out there because frankly, we're recording this. So if you have a specific question that's for your specific circumstance, it would be best to send something to our email address. There we go. So again, I am Tina Lee Vogt. I'm the program manager with the program. With me today is Vicki Riggins Medina. She's the program specialist for the program. And when I say we, I'm really talking about Vicki and her very capable staff that actually manage the program. Also joining us is Cheryl Patterson. She's the senior deputy city attorney who advises us and gives us great clarity on different questions and issues that come up in terms of interpretation of the code. Also joining us are Tahiri Kraft and Virginia Perez with Sacramento Self-Help Housing. They've been an amazing partner with us. And so they'll be able to provide information on their program, which actually goes beyond the services that we at the city provide. So we're just going to give a little bit of background information on the Tenant Protection Program. So the program was initiated in fall of 2019 by the Sacramento City Council. And the ordinance adopted the program. So what we do is we assist tenants by ensuring compliance with limits on annual rent increases and protections for unjustified eviction. So we probably have about 8,000 or so parcels that are in the program, and those parcels have about 42,000 rental units on them. So again, what does our program do? We assist tenants and landlords with questions and concerns. We facilitate different hearings, and we interpret and enforce the code. We partner with Sacramento Self-Help Housing, who triages calls and assists tenants and landlords with inquiries, as well as sharing information on other resources that are available. Because again, our program only covers so much. So Sacramento Self-Help Housing does a great job of being able to assist tenants with those issues that may not be protected by our program. So last March to December, kind of the height of when things were going on with COVID, we had over 2,000 contacts with tenants and over 500 contacts with landlords via email and telephone. So there are three major components to our program. First is rental property registry and program fees. This is most closely related with our landlords. We also have a maximum rent increase limit and then eviction protection. So those are the three key components that make up the Tenant Protection Program. So let's first talk about what's subject to the program. So it's multifamily units built before February 1995, mobile home rentals, and single occupancy rooms in hotels that are longer for 30 days. Exempt or anything built after February 1995, single family homes, condominiums, units that are occupied by the landlord or property agent or immediate family, and government subsidized low income housing. So the first component again is rental property registry and program fees. A landlord must annually register all units that are subject to the Act. And our registry is consistent with information that's in our rental housing inspection program. But I do want to make a clarification because people continue to ask, if I'm in RIP or the rental housing program already, why does my property need to be registered again in the tenant protection program? Quite simply, there are two simple programs, different programs with two different ordinances. The most basic way to understand the differences is that when you're thinking of RIP, it really deals with the property. It deals with the quality of the structure and making sure that it meets building health and safety codes. When we're talking about the tenant protection program, it really deals with people. It talks to those relationships between the tenant and landlord and those legal documents and processes that go with them. So again, tenant protection is about the people, rental inspection is about the building. So for registration, we have already mailed registration packets to our landlords that are subject to the code. So we'll eventually have forms available to register if folks don't get those forms. However, we really would prefer that landlords wait until they get their packet. That packet is already pre-populated with information that we took from the Rural Housing Inspection Program, which quite frankly makes it easier for you to complete and return. It also has information that makes it easier for us to upload it into our system. So if you haven't received your information, just wait a bit. If you haven't received it by early April, contact our office or look for those forms that'll be available on our website. So it's a two-step process, very similar to RIP if you have property registered with RIP. So what we're doing is registration is the first step. The second step is going to be invoices. We'll be mailing invoices sometime around mid to late April. If you've gotten your registration packet, please don't return it with a check. We'll be sending you an invoice that you can return separately to pay. You'll also be able to pay online for convenience. The annual program fee is $20 per rental unit. It's really critical that registration packets are returned, especially if you have properties that are exempt, such as they've been sold or the landlord is living in perhaps a duplex and they're living in one side. The invoices are going to be based on the rental units that we have on record. So if you have a rental property that has 5 units and you have 2 that have someone that's getting a government subsidy, you want to make sure you get that exemption to us so you aren't billed for those 2 units. So the other component of the program is in regard to rental rate increases. The annual rental rate increase cannot exceed 5% plus the CPI, and it will never be more than 10%. So our current rate is 6%. The maximum rate is updated annually on our website on July 1st. So we just wanted to find what's included in rent because sometimes there's some confusion. Rent may not be simply the money that you pay for the actual apartment or duplex. It includes all charges for use and occupancy of the rental unit. So that includes any separate charges for housing services such as utilities, parking, or pets. For those charges that may differ monthly, the landlord has to calculate the monthly average for the prior year and include it in the monthly rent, which is subject to the maximum increase limit. This is really important for tenants and landlords to understand, especially if there's a change in how housing services are applied. For example, if a unit was rented and then everything was inclusive and the landlord then decides to charge a separate fee for utilities, that additional charge that's included has to still be within the cap. So it still need to be within that 6%. The rental rate can't be increased any more than once every 12 months. So you can increase it in January and then increase it again in August, even if maybe the person's lease comes up in August. It's only every 12 months, and it applies to all tenants regardless of how long they've resided in the unit. Also, that increase cannot be waived by the tenant. So the landlord can't say, well, the tenant agreed to a 12% increase. The limit is 6% for the current year. That's the maximum they can increase it. If it's increased by more than that, then that's a violation of the code, even if the tenant doesn't complain. And if we find out that it's that, we can follow up and tell the landlord that they need to have it go back to the 6%. If tenants do believe that they've had their rent increased unfairly, they can submit a complaint to the city and we'll follow up on it. So if the tenant moves out, either they vacate voluntarily or the lease is terminated in accordance with the ordinance, then a new base rent level can be applied. So the landlord may establish base rent for a new tenant under a new rental agreement after the rental unit is actually vacated. And any rent increase for the new tenant must comply with TPP maximum rates after that. So what if a landlord really believes that they need to go above the 6%? We do have a process called our fair rate of return hearing. So they can go ahead and submit a petition to the city for a hearing. We're working on and we're really close to finalizing our administrative procedures, which will be available online, and it'll outline the process to submit a petition. There's no fee that's required to have this hearing. However, there is documentation. It's not just enough to say, oh, well, the rents have been historically low, or we just think that we need to raise them to be higher to be competitive with the market. There are different justifications that are required and documentation that will be necessary. The hearing examiner will decide based on the facts, and that decision will be final. So the hearing, the process and procedures have more information in terms of the process, but here's a few things that are documentation that's considered acceptable and unacceptable. So, for example, if you have to have a planned capital improvement to comply with health and safety code, a debt service payment, a significant increase in housing services, those may be acceptable reasons to do it. Ongoing operating and maintenance costs are not. Remodeling, simply deciding that you want to have a different carpeting is not a reason to increase the rent. So, or penalties from the Sacramento City Code related to the unit. So again, the process, policies and procedures have more information, but these are just some a little summary of what's acceptable and what's unacceptable. The third component relates to eviction protections. The landlord must offer to renew the rental housing agreement if the tenant has resided in the unit for more than 12 months. That's 12 months plus 1 day. Evictions are prohibited without just cause once the tenant has resided in that unit for that time. The landlord must agree to extend or renew the lease before it expires for the just cause eviction protections to become effective. If the landlord notifies the tenant that the lease will not be extended before the lease expiration date, the tenant is not entitled to eviction protections. That status does not change if the tenant remains in possession past the lease expiration date as a holdover tenant until they vacate the unit. This is again when it's really important to contact our office if there's a specific situation, and we need to look at it a little further because each situation is unique. So here are the just cause protections, reasons, failure to pay rent, breach of the rental housing agreement, criminal or nuisance activity, failure to give access, necessary and substantial repairs requiring temporary vacancy, owner move-in, and withdrawal of the rental unit from the rental market. Again, these are some things that are defined in more detail in our processes and procedures and in the ordinance. So the pre-eviction hearing process. If a tenant believes that they've been aggrieved by the landlord in violation of the code, they can request a hearing examiner review. The program procedures, again, outline this. It'll be available on our website. And again, there's no fee for this hearing. And the hearing examiner's decisions are final. If the hearing examiner upholds the tenant's petition that the landlord does not have just cause, the landlord cannot proceed with the eviction. So tenants can submit a complaint to the city if they believe that a landlord has violated the code. The city will investigate to determine the facts and if a violation has occurred. Want to make sure that it's very clear to tenants that we're not doing this because we don't believe that the allegation occurred. That tenant has that landlord has a right to due process, and we just want to make sure that we understand all of the facts. And then once we have all of the facts, we'll make that determination. I think sometimes there's a concern when we question or ask for additional information that it may be interpreted that maybe we don't believe that that tenant has a valid complaint. It really is, again, with any code violation, whether it's a violation of this code or any other city code, the city is responsible for following due process before we move forward with issuing any enforcement actions. Any landlord who violates a provision of the code is subject to criminal sanctions, civil actions, and administrative penalties pursuant to Chapter 1.28. And administrative penalties may be imposed up to $25,000 per offense. The landlord's failure to comply with any requirement of the chapter is an affirmative defense in an unlawful detainer or other action brought by the landlord to recover possession of the rental unit. So, how can a tenant request assistance or file a complaint? So, they can either contact the Tenant Protection Program or the Renters Helpline. So, to make sure that tenants get the best or most immediate assistance, here's some of the things that we'd like you to do. First, we may need to make sure that you provide us with your name and contact information, an email, a phone number. We need to have the rental unit address. You'd be surprised of the number of contacts we get from outside of the city. We get them from Dallas. We get them from obviously the unincorporated part of the county. So it's really important that we have that rental unit address. It's also important that if you have any documentation, like if you have your rental housing agreement or to understand that your date of tenancy, please specify the reason for the request. We get a lot of emails and phone calls where people simply say, I need help. What that does is requires us to then have to call and ask what kind of help is needed. So if you're very clear about what kind of assistance you need, that makes it easier for us to respond. Any documentation that you've received, did you get a rate increase? Did you get an eviction notice? Anything that you've received is helpful so we can better understand your situation. And then finally, contact information for the landlord or property management company, because we're going to need to follow up with them. And Vicki's going to go into a little bit more detail about how her staff follows up and the best way to work with them to make sure that you get your issues resolved, as will our folks with Sacramento Self-Help Housing. They'll also talk to you about how to contact their program and how to get the best assistance. So how do you contact us? So again, this is information on how you contact us. This is going to be available. The PowerPoint is going to be available on our website. And also, if you visit our website, you will actually see this information posted there with some really great links that make it easier for you to reach us. So again, you can contact the Tenant Protection Program via email at tpp@cityofsacramento.org. You can reach Sacramento Self-Help Housing at Renters Helpline at I can't speak English. Renters Helpline at sacselfhelp.org. One of the things, and Vicki will probably go into a little bit more detail, but I do want to make sure that people note that contacting us by email, especially right now, is probably the best way to reach TPP. Much of our staff is working from home. And even though we respond to our phones as quickly as we can, it's a much faster response when you respond to us via email, because anything that you contact us via phone is going to go to voicemail. So in terms of upcoming events, we plan on having another webinar sometime in May. At that time, we'll have more of our program implemented and we'll provide more updated information. So please look at our website for those dates. We'd also like, if you have an organization or a group that would like to have more information, and maybe we can even have it more focused to address your specific concerns, please contact us. Outreach is very important to us at this time. And so we're trying to reach as many tenants as we can to make sure that they understand their rights and their responsibilities. So please go ahead and contact us at tpp@cityofsacramento.org and let us know if you'd like us to come and speak to your organization directly. We can work with you on how that presentation would flow. So that's all I have for my presentation. So I'm going to go ahead and turn it over to Tahiri with Sacramento Self-Help Housing.
Thanks, Tina. My name is Tia Craft from Sacramento Self-Help Housing. I want to understand that we are providing or working with the city to provide both renters and owners with education and dispute resolution. Now, our focus is on the rights and responsibilities of owners, and tenants. We really want to triage those phone calls. So if you're calling and say, I don't think this rent increase is acceptable, that's why I have phenomenal staff to work with you and kind of talk through the questions, to come up hopefully with your solution. We also are trying to expand, as Tina mentioned earlier, there's a lot going on with COVID and the moratoriums. So sometimes it could be a multi-layer issue that we have to unravel. So we're here for you for that reason. Now, we do offer a multi-language line of over 200 different languages. So if my staff cannot speak with you in the first, we will get you on top of you on the renters helpline on the language line. So please give us a call. If I look forward to talking with you, and hopefully we can answer more questions today. So thank you. Back to you, Tina.
Okay, thank you so much, Tahiri. So I'm going to go ahead and pass it over to Vicki Riggins Medina. Vicki is our program specialist, and she directly supervises the program. So Vicki.
Good afternoon, everyone. Thank you for joining our webinar this afternoon. I'm just going to touch on a few things related to how to contact our office and the best information to provide to us in order to follow up on your current situation. And so I'll start with emailing. I'm going to reiterate what Tina indicated earlier. It is best to contact our office by email. And it's very helpful if you do provide the property address, because we first would like to verify whether the property is located within the Sacramento city limits. Oftentimes, we receive email requests to follow up on the situation, and the property is actually located in the county of Sacramento or the unincorporated areas of Sacramento. So it is very helpful that you do provide the property address. We would like to provide you with the most accurate information as possible. And so it is helpful having that information. Additionally, when we are emailed, if you can provide a brief description of your current issue, that is also helpful as well, because we want to be able to determine the best assistance to provide to you. It could be that we would need to refer you to the Sacramento Self-Help Housing for additional assistance regarding your tenant rights. If you contact our office via phone line, again, Tina indicated we are working remotely at this time. And if you could leave your telephone number with a brief description of your issue, that will be helpful, along with the property address. We have found that oftentimes when we return calls, because we are working remotely, it may come up as an unknown number. And if you have contacted our office, chances are we might be the individuals calling you back to follow up on your voicemail message. And additionally, if your voicemail is full, there's of course no way we'll be able to leave a message for you. If you find that has happened where you discovered your voicemail is full, please contact our office and we will follow up with you as soon as possible. But the best way to contact us at this time is via email at tpp@cityofsacramento.org. I also want to make mention that staff does follow up. We try to follow up within 24 to 48 hours, and depending on what's actually going on within our office, we try not to make it more than 72 hours, but we do try to follow up within 24 to 48 hours. If there is a complaint that you would like to file with our office, we do take time, we do investigate that complaint, and we try to ensure that we gather facts for not only the tenants, but the landlord as well. So that may take a little bit of time, but if we're provided with the proper information, I would like to include landlord contact information as well, we can follow up on that complaint. And that's all I have for this afternoon. Thank you.
Okay, so I don't know if anyone else on the panel has anything else that they would like to add or share before we start taking questions.
I think I'd like to address something that's come up. Sometimes tenants ask us, they want to remain anonymous because they're concerned their landlord is going to take retribution because they called our office for investigation. And we do try to keep the information that of the tenant's name who complained anonymous initially. We just send a letter to the landlord saying one of your tenants has complained, and please, we think your rent increase was too high, or you might not have the right justification for eviction. And so initially we will try to do our best to keep it anonymous, but at some point, if we have to go into enforcement, we're going to have to show the landlord the letter that we got from you that says the rent was higher than 6%. We're going to maybe have to use the documentation you give us. So at some point in the process, we may have to identify who the tenant is, but initially we try to meet your request and try to keep your name anonymous.
Okay, thank you, Cheryl. So we have just a few questions that have been asked. One of the questions is, when will you actually publish the administrative procedures? And we know that there's been a delay in that, and that we've had some different things come up. And we had, and at one point we were ready, and then we realized that there were some clarifications that we needed to work on with our attorney's office. And so we've addressed those. Our procedures have been reviewed and approved by our department director. So we're probably looking within the next few weeks being able to get those posted with the related forms. However, if you need assistance, especially if you need assistance for an eviction, don't delay in terms of contacting our office and letting us know that you need assistance. It's really important, especially if you get a notice for either a rate increase or an eviction. Don't wait until that's going to be effective, like a day or two before. Contact our office as soon as you receive that. Even if we don't have the procedures up, we can still assist you and work with you to address the problem. Since we had the program started in fall of 2019, we've worked on behalf of a number of tenants, working directly with their landlords to get their rate increases decreased. We've worked with them in terms of having eviction notice rescinded, because we've been able to address it in different ways. So we don't want anyone to think that because those procedures aren't up, that we can't provide assistance. The other thing that I would really strongly suggest is our website's going to be updated pretty much consistently as we continue to do implementation. As we add forms, we need to update and add our different FAQs. We're going to add information on different resources. We have different links for information on COVID. So if you haven't already done so, there's the ability on our website to sign up to be contacted if we change the website. So I would strongly urge you to sign up so that we can contact you. And we'll also be following up with people that have signed up for the webinar, because we do have your email addresses. They'll be following up with you as well. So if you'd like us to make sure that we send you notice, we can go ahead and make sure that we notify everyone that's participated in our webinars when different things are updated on our website. Cheryl, did you have something to add?
Yeah, I've noticed in the questions, one of them was, what happens when the landlord retaliates against the tenant because they made the complaint? Well, we enforce the ordinance against the landlord if the landlord is violating the ordinance, the rent increase, the eviction protections. So if a landlord is retaliating because you filed a complaint, we find the complaint is valid, we can actually find the landlord and take enforcement action. So that's how we handle retaliation if they're retaliating and violating the ordinance. If they're retaliating against you and it's coming up to the point of discrimination, there are other avenues to address discriminating against tenants. The other question that came up was, what kind of information do we need regarding the pre-eviction hearings? And that kind of information basically is, we of course want to know what the lease says, what the landlord's notice for the eviction, what was the justification they believe for the eviction, what the tenant maybe responded. And once we get those documents at the pre-eviction hearing, the hearing examiner looks at those documents and asks questions of both parties and then makes an independent decision whether to uphold the tenant's petition and whether there is justification or is not justification for that eviction. And that hearing examiner's decision is final. And if the hearing examiner upholds the tenant's petition that the landlord did not have just cause to evict, the landlord cannot proceed to evict that tenant in the eviction courts. That hearing examiner's decision is going to be something that the judges and the eviction courts will recognize and will accept and will deny the eviction unlawful detainer petition by the landlord.
So I think, I don't know, Sheriff, if you want to take a look at there's some other questions in the Q&A that are a little bit more specific. And so I don't know if you feel comfortable addressing those directly, openly, or if we want to address those more, having folks maybe get back in touch with us. Because again, sometimes specific questions, for example, there's a question regarding the maximum allowable rent. And I think there are so many different factors that might be included in that, that it may be best to send your specific situation with your specific tenant, even if we don't get the tenant's name, so we can determine kind of what works best for you. I don't know what your thoughts are on that, Cheryl, if you want to go ahead and give that one a shot, or how you want to work that. So
Okay, I did see a number of them. There were some very lengthy questions. It looked like a specific situation. That'd be best if you email us with that question so we could respond appropriately. There was another question. Another question was, is a landlord required to renew the lease? So if the landlord is willing to have that tenant stay in that unit longer than the first 1 year, the landlord generally offers the tenant a lease renewal. Under our ordinance, the lease has to be on the substantively the same terms and conditions. So for example, the landlord can't take away your parking, or they can't, deny you the right to keep your pet if that was already authorized in the prior lease. So it's the same terms and conditions. Now the two parties can agree on something different. The two parties can agree to modify what the lease says if they both agree. But the landlord cannot force the tenant to accept a new lease that has onerous provisions or something that's not the same, substantially the same as what the prior lease said. So if you have that situation, again, send us an email, send us a copy of your old lease and the new lease so we can look at it, and then we can engage the landlord and make those corrections.
Okay, one of the questions that came up was regarding hearing examiners, and I did actually answer it in the chat, but I did want to make sure that folks knew this as well. We do have 2 hearing examiners that have been appointed that were recruited via a request for proposals process, because we were really looking for folks that were specifically knowledgeable in landlord-tenant issues. So we have 2 hearing examiners that are on board and available. And had we gone to a situation where we really needed a hearing, even without our policies and procedures in place, we actually have a city kind of hearing process that we could have utilized on an ad hoc basis to hear cases, and then those folks could have heard them. So we do have 2 hearing examiners that have been appointed by the city council who are specifically appointed to hear tenant protection cases based on their qualifications and experience.
One of the questions was, where does it say in the ordinance that the landlord has to offer that lease renewal? What the ordinance provides is the basic framework, and it included a provision that we can adopt administrative procedures. And in our administrative procedures, which are very lengthy, we go into very detail about what the ordinance means and what the requirements are. So when you see the administrative procedures, you'll see there where it says the landlord has to offer to renew the lease to the tenant once they've been there longer than a year. So some of your questions and some of your interpretation issues, you'll find in the administrative procedures.
And then we had another question regarding when we plan on having the webinar. Actually, we reached out to some folks about when we should have our next tenant webinar, and this was a time that was suggested to us, but we're always open to having additional webinars. So if people would find it useful for us to have our next webinar that we have in May, to have it either in the evening or a weekend, we are completely open to that. I know that I've participated in a number of different webinars and meetings at the request of council members that have been in the evening. So people can request us again to come and speak directly to a group, and we're always open to that. And if you have suggestions in terms of dates and times that would work best, go ahead and send those to us at tpp@cityofsacramento.org, and we can schedule those. So we're more than happy to have these at different times. Again, this was a time that was suggested for us to have it. We were asking about having our tenant webinar. But if people would think it would be better in the evening or on a weekend, years of city service makes me know that sometimes daytime hours don't always work best, and we're more than happy to accommodate that.
And I also want to tell folks that if they have concerns about our ordinance, or they think some of the provisions are not fair, or should be modified, we're also looking for that kind of input. So you can send an email to TPP and let us know what your criticism of the ordinance is, and we'll take that into consideration, because we're going to go back to council and give them an update about our ordinance going forward too.
So in looking at the questions, are there any other questions that the panel would like to go ahead and answer at this time, or that we feel is appropriate for this forum? I'm just looking. So I don't know if Tahiri, if there's any questions or anything else that you'd like to add in terms of questions. Again, if your question isn't specifically answered, please feel free to send us an email directly, and we can go ahead and address it that way as well. So
One more question was, what happens if the tenant doesn't have a written lease? And our ordinance applies even if there's no written lease. You know, sometimes landlords and tenants just have an oral agreement of what the lease terms, what the rent's going to be. That tenant is still protected under ordinance, even though I don't have something in writing. So again, any tenant who's occupying a rental unit with the landlord's permission, whether it's in written form or not, they are protected in terms of the rent increase. And after 12 months, they're protected in terms of eviction protections.
So one other question that came up, Cheryl, and I think this kind of speaks to the importance of contacting us and why we're really trying to get this information out, is the landlord forced me to move out a few months ago, and I now realize that I think I met all the requirements to be protected by the program, and I still request a hearing even though I've already moved out. So
Unfortunately, no, because our hearings are pre-eviction hearings. Our hearings related to the dispute that the landlord says you've breached the lease and you need to move out and you disagree with that, then we would have a hearing before you're actually evicted. And so if you move out because you didn't want to go through the eviction process, or you moved out voluntarily and now you realize your rent was too high, it's too late. We have to deal with you with your situation when you're occupying the rental unit, between the relationship between you and your landlord at that point in time. Because basically we don't have jurisdiction anymore once you've moved out.
okay.
But we can complain about the landlord. We can look at what the landlord did. And if the landlord really was onerous and violated the ordinance, even though you moved out, we might still take an adverse and enforcement action against that landlord for that violation. So you can still let us know about it. We just can't give you a pre-eviction hearing.
And then one of the questions is, for the questions answered live, we will also write the answers here. This is going to be recorded, so if anyone wants to go back and look at the recording, they should be able to go back and see kind of what that answer is. So we're going to have that posted pretty quickly. So we already have the last webinar posted on our website. I'll be working with our public information staff to get this posted just as quickly. So if there's something that you missed or you want to share it with other folks, it's all going to be available via recording on our website.
And I just want to step in before we say, a lot of these questions are very detailed. I cannot stress enough, like you said, please give us a call so we can get these detailed information, and staff members can work with you on what is the next step or what are your rights and responsibilities. So please give us a call.
And actually, it's really helpful for us if we see questions like that, because we're going to be working on updating our FAQs. Initially, when we had the program, we had a long list of FAQs, and they kind of became a Frankenstein and they were disorganized. And so what we're really hoping is to come back with a better version of our FAQs that are more clear, that they're clear for both landlords and tenants, and they really talk in terms of the three components and the issues that we have. So if you have questions and you send them to us, that's actually very helpful, because what that does is that lets us know what questions or issues that people have that we need to make sure that we address in our FAQs. And again, it's always really good for us if you can send us an email, because that kind of lets us know what concerns people have. And really good feedback too is whether or not I'd like to know if we should be having another webinar sooner versus later. We had planned on having one in May, but if folks think that it would be better for us to have another webinar that's available to tenants maybe in the evening or on a weekend in April, that would be good information for us to know now, and we can work on planning that. And again, any organization that's joined us today that would like to have us participate so we can make sure that we get the word out. As you can see from the information that we're sharing, it's really important for tenants and landlords, but especially tenants, to understand their rights and to get to us sooner versus later. So we really want to get information out to people so that they know ahead of time, you know, what's available to them in terms of resources and processes. So if they do have complaints or issues that need to be addressed, they're talking to us before they receive an unlawful detainer or before that rate increase is effective. So I don't know if the panel has anything else or if there's any other issues that we need to address, or anything else that folks see in the questions that feel that are appropriate for us to answer at this time.
I just want to also remind people resolution. So we want to be able to talk to you, and if you need us to talk to the owner or landlord, we will try to solve the issue, of course, any further by educating both parties. So we do offer that service.
Okay, so does the panel, so Vicky, you had another comment?
I also want
Yes, and just as Tahiri was saying, you know, we do try to reach out to the parties to obtain additional information when there is an issue. And so I would say for tenants, you know, to provide us with the information so that we can follow up not only with the tenant, but with the landlord as well. We remain a neutral stance. We're not partial to either side. Again, we are just gathering facts to help in resolving whatever issue that you have.
Okay.
I also want to mention that we also are offering free mediation services between landlords and
Thank you, Cheryl.
tenants. And that's going to be really important because we know because of COVID and because of state law that many tenants haven't been able to pay their full amount of rent, and that back rent debt is looming. And so, you know, we do offer mediation to deal with the back rent issues, even though it's not part of our ordinance per se, because it's the COVID issue. But we also, it's a mediation process. Sometimes that's the best solution rather than going to an administrative hearing when there's an opportunity for both sides to understand each other and what the rights are. So that's a free service, and the information is available on our website as well.
So a question came up whether or not we've prevented evictions via our mediation program. Fortunately, we don't have our mediation folks on the line with us, but I believe that they have been able to get people to work and negotiate. I know through our process in terms of following up with landlords when they've incorrectly issued evictions, we've been able to have success. I'm not as, I believe with our mediations, we've been able to do that as well. Unfortunately, we don't have someone participating, and that may be something, if folks think that would be helpful, at our next webinar, we can invite our mediation program to join us as well. So maybe for our next webinar, we could actually include our partners with the Sacramento Mediation Center so that they can actually explain mediation services. So if people think that would be helpful, we'd be more than happy to include and have them join us as well. And then one question that came up is how if a landlord had someone that was, I think, maybe a holdover from COVID, if they got past the year, whether that impacts. So I don't know how you want to address that one, Cheryl.
Yeah, if the landlord has not offered to renew the lease, our ordinance is based upon the landlord willingly wanted that tenant to stay in that rental unit longer than a year. After the 1 year's up, they offered the tenant to stay. If the landlord's been unable to evict the tenant because of the state law on COVID, that tenant doesn't have lease rights. That tenant's what we call a holdover tenant. And just because the eviction courts have been closed and the landlord's been unable to evict a tenant and the tenant's been sitting in the property longer than 12 months, that does not trigger the just cause protection under our ordinance. And that's, again, explained in our administrative procedures. And it's the same thing under state law. AB 1482 says a tenant that's been in the unit longer than 12 months gets the just cause eviction protections. Again, you have to be in the unit longer than 12 months with the landlord's consent. If you're a squatter, you don't get eviction protections.
Other thing in terms of our mediation, it's not legally binding, but what we're hoping is that through the mediation service that people come up with some kind of actual agreement that they both sign off on. So it's not a legal binding, it's not arbitration or something that they're legally negotiating, it's mediation, but we're hoping that in the end, people come up with something that they can both live with and then move forward. In terms of whether or not we think landlord, another question that came up is, if landlords are going to go after back rent through small claims, that remains to be seen. There are so many unknowns with this. There's different types of resources that are available that if landlords are willing to accept a percentage, that they can, you know, get some cost recovery. There's a lot of different layers to this problem. So at this point, it's difficult to say whether or not they will go after folks in terms of back rent through small claims court. but we really should have tenants and landlords working together. That's why I'm really happy that Cheryl brought up our mediation services and that open communication. And again, really reaching out to Sacramento Self-Help Housing, because they also offer that as a resource in terms of being able to help with disputes and being able to connect landlords and tenants. One of the things that we found, especially early on during COVID, was that folks were unwilling to talk to each other. We would get tenants who didn't want to approach their landlords, or landlords who had, who really wanted to talk and they were having trouble connecting. So communication is going to be really key as we work through this. We really wanted to get our information out too, because we're not sure what's going to happen in June. We know that the state moratorium is going to end. It remains to be seen whether or not it'll be extended. It all depends on circumstances and where we're at with COVID. So we want to make sure that folks are aware of the resources now and are kind of making a plan and an approach, because we just don't know what June holds. So the more information that people have and the more access they have to resources, the better they can plan. So they're not waiting until it's June 15th or June 29th, and then they're trying to figure out what they're going to do, whether or not the moratorium is extended.
I was just gonna say, under state law, if you haven't been paying rent because of COVID-19 financial impact, and you've been filling out that declaration form and sending it to your landlord and paying your 25% minimum rent amount, under state law, the back rent that's owed starting in July 1st is when that state law ends. So all the back rent owed, the landlord cannot evict you for the fact that you haven't paid the back rent. They can only go to small claims court and try to get a judgment. And the small claims court process, as well as our mediation process, is there to help actually come up with a back rent payment plan. The other thing I want to let you know is that if you're in a rental unit that was built after February 1st, 1995, our ordinance does not apply because the state law limited us. But there is a state law, AB 1482, that's substantially the same as the city's ordinance. The rent increase limit's the same 6%. The just cause evictions are based on the same reasons. And so the implementation of your ability to use that state law, unfortunately, is only in the eviction courts. You have to go in front of the eviction judge and explain why you've been there more than 12 months, the landlord does not have just cause. So that's how they're enforcing the state law. So you still have the same protections. You just don't, unfortunately, have the city's process where we can go in and assist you with that enforcement or give you a pre-eviction hearing, but you still have similar rights.
So one question that was asked is whether or not we have data on geographic locations where there have been numerous complaints to tenants, or the types of complaints that we have. At this time, we don't have that data generated. We could work to prepare that. We haven't done that yet. So that's something that we could work on. COVID kind of throws a little bit of a kink in terms of skewing information here and there. One of the things we've also been working on is updating our database. That would make it easier for us to generate that information. But that's definitely something that we're going to want to look at to understand maybe where the impacts are greater in terms of the need for tenant protections. So that's a great question. I definitely think that's something that we need to keep in mind, because we definitely want to know what geographic areas are most impacted by different tenant related issues, and then being able to address that. But we'll definitely be following up on that and hopefully be able to provide a response of that data, in future reports that we need to report back to the city council on in terms of the program effectiveness. And then there's a question, and I'm not quite sure if we might need some clarity on this one, Cheryl. If they paid all the rent, you can still evict them. They are not protected by just cause. I'm not quite sure what that's related to. So
I think it's related to the issue again as a holdover tenant. The landlord sent him a letter, said, I'm not going to renew your lease, and the lease is going to end, let's say March 30th. And they're still there April 1st, April 2nd, and they're sending the landlord money. Now, landlord tenant law can basically sometimes say if the landlord keeps accepting your rent, then you basically have a month to month and you continue on. But under our ordinance, again, if they send you a notice that said they're not renewing your lease before that 12 months is up, just because you haven't moved out yet and they got to go to court to get an eviction order does not give you rights under our ordinance. It has to be the landlord's consent. You're longer there than 12 months.
Okay, and then there's another question about what about tenants who have been there more than 12 months but have not availed themselves of COVID protections?
Well, you've been paying rent then. If you've been paying rent, and then you don't have a problem. If you haven't been paying the full amount of rent, there's state law was very clear about the process that you had to go through. The landlord had to send you a declaration. You had to fill it out and send it back in. If you didn't follow state law and fill it out and send it back in, you're not protected under state law. That landlord could take you to court tomorrow and get you evicted. So again, the COVID state law has certain procedures, and the landlord's required to give you notice and required to give you the declaration if you aren't paying the full amount of rent, and you have to, under state law, pay at least 25% and return that declaration if you want to have the protections under state law that says the landlord cannot evict you before the end of June.
And then does this apply also to a 2-year fixed lease?
Yeah, once you've been there more than 12 months. So 2-year fixed lease, if for some reason landlord's terminating it, because he's got the right to terminate it before the 12 months are up, then you don't become the just cause protections. You have to have been living there with the landlord's consent longer than 12 months.
Okay, and then someone asked, how would people know about specific details in our administrative procedures if we have not published them? For instance, what we said about the lease renewal. Lease renewal, I believe, is more related to the code or state law. The procedures are more about our processes. And our city code is available on our website. So if you have anything that's actually in our ordinance, it's available on our website as well as our just overall city code. The processes and procedures are more detailed information on how to avail access to the different rights that folks have. Would that be correct, Cheryl?
Yeah, and you're going to post your administrative procedures. People are asking about those. They'll be posted shortly, and once it's posted, you can read them and have more clarity about how our ordinance works.
I'm seeing if there's any additional questions. Okay, if you have a more detailed question about something related to a lease, or because I think they're kind of drilling down. Again, those are the kind of things that it's really best to send us an email. And then that way Cheryl and Vicki can really look at the different issues that are involved and then provide you with the best response. Because sometimes it's what we really want to avoid happening, especially if you have a more specific question or issue, is trying to give you an answer on the fly during this webinar and then not have all the full details and give you information that may not be correct. I know that's something that happens frequently, is that people ask questions, but there's details or different nuances that are missing. And so the information could change based on a key detail that we're not getting in this forum. So if you have a specific lease question, it's a specific lease with a specific tenant, and you want some clarity, that's when it's best to go ahead and send something to our office directly. And then that way we can give you the best answer. Because what we don't want to do is tell you something in this webinar for you to take that as gospel or to take that as accurate, but there's missing information that our staff might have needed and then have it be incorrect. So I think with that question, again, sending that directly to our office would be the best way to ensure that we provide the best response for your particular instance.
Oh, why don't you give them the email address again?
So again, the email address is tpp@cityofsacramento.org. And again, our presentation is going to be online, and it'll include all of the information that was in the PowerPoint. And I'm also going to ask our PIO to separately just go ahead and post a PDF of our PowerPoint presentation. So if you just want to be able to go through the PowerPoint presentation without having to listen to me drone on, you could actually just look at our PowerPoint presentation and get to the slide that has the information that you need. So I'll work with the Public Information Office, and then that way you can have that PowerPoint and then you can refer to it and you can share it with others, but you don't have to listen to the whole presentation to get to the slide that you want to hear. So
and if you want to get that information from our website, just search Tenant Protection Program and it'll take you right to the page.
And just to check with our panel, are there any other questions that we see that we need to answer? I think there's just one more question. Is there a requirement to offer a renewed lease on the same terms contained in the city ordinance? So do they have to issue the renewed lease in the same terms?
Again, it's in the administrative procedures that explains how our ordinance works, and it explains that particular issue about the landlord having to renew the lease once the tenant's been there in the unit with the landlord's consent longer than 12 months. So you'll see that in our administrative procedures.
But do they need to be the same terms?
Substantially the same. So
Okay.
again, the two parties can agree to something different if they both agree. If they don't agree and the landlord's imposing a new term that the tenant feels is pushing them out the door because they can't comply with that term, such as, can no longer have your pet, let us know and we'll respond with the landlord and we'll educate the landlord about what our ordinance says. But it's in the tenant, it's in the administrative procedures, the specific issue that you're asking. And
Okay,
you can show the landlord, you can refer your landlord to administrative procedures too. That might help solve your problem directly, so.
okay, but I know that we're working on getting our procedures, so I just want to be able to at least hit the highlights for folks that are in this hearing. So again, because we know we're going to be getting those out, but since those aren't currently out right now, want to make sure that we can at least address a little bit of what their concerns and their questions.
Right, right.
So I'm just trying to see if there's anything else that we need to cover in this particular forum. So I'm going to ask the panel if there's anything else that we have missed that we want to address at this time. So again, if you feel like, you know, your question wasn't covered or you just need a little bit of additional information, I have put our email address in the chat. So you can go ahead and send an email to us directly. If you have any issues, questions, or concerns with our program, please send us an email and we'll follow up. One of the things I always say is I currently manage a number of different programs, including the Tenant Protection Program. And for any of the programs, we're always a work in progress and we're always open to getting new information and feedback. So if there's different questions, if you have questions regarding our process and procedures, if you have concerns, please reach out to us and let us know. The more specific, the better, because we can't fix what we're really not aware of, and we can't address something if it's vague or it's unclear. So if you have something that you would like us to follow up on that we haven't addressed today, please send us an email. If you have a suggested date and time that you would like us to perhaps have another webinar, that's something we can consider. Again, we're looking at having a follow-up webinar sometime in May. That might be something that we could have either in the evening or on a weekend. If there is a desire to have us have another webinar before that, that would actually be very good feedback for us to have as well. So if you think it would be helpful for us to have another webinar, perhaps on an evening or on a weekend, please let us know. And that's definitely something we can work on. We really want to get as much information out to tenants directly as possible. So any suggestions that you have in terms of really good ways for us to reach out and you know, contact folks and share information, please let us know. We really appreciate you taking your time now to attend. Again, I can see that sometimes it's a little bit of a concern because we know that folks work. And again, this was a time that was recommended to us to have the webinar, but we're always open to other suggestions and trying to have it at different times. Also, we have tenant information that's available that we can share. So if you'd like to request information, we have flyers that has summary information on our program that we can provide. We have rack cards that are the little smaller cards that people can print on their own, or we're going to get some of those printed. We also have flyers that we can send to you. So if you would like to get a copy of our flyer that you can share with other folks, just send us an email and we can go ahead and send you a PDF of that you can share with other people. So with that, I'm just going to ask if there is any other information that the panel wants to share or any other issues that we need to address.
I just want to remind everybody that, you know, there's issues that our ordinance does not cover between landlords and tenants. And, you know, there's state laws about COVID, and maybe, you know, a rental unit is newer than February of 1995. Please call Self-Help Housing. They're there to give you all the advice you need, landlords and tenants, about state laws and your issues that might go beyond what our ordinance covers.
Yeah, absolutely. I'll add to that. You can also email questions if for some reason you're at work and don't have time to pick up the phone. You can go on our website, which is rentershelpline.org, and send us your questions via email. We are open Monday through Friday from 8:30 to 5 p.m. And if you have to leave a message, our turnaround time is 24 hours. We will call you back. We also make 2 attempts to try and reach you if for some reason we don't get you the first time.
So with that, I'll see if our panel has anything else that they want to add. So Cheryl or Vicki, if you have anything else that you want to add at this time.
I think we've covered my issues.
Okay.
No, I think we covered everything. Again, reiterating that please contact us via email as we are working remotely at this time. And our hours are from 7:30 to 4 o'clock, Monday through Friday.
Okay. Well, thank you so much for taking the time. This will be posted again on our website so that people will have available and access to it. Again, I will work with our public information folks to post the actual PowerPoint presentation separately. So then that way, if you just want to get to a slide really quickly with information, again, if you want to request a copy of our flyer so you can share that with others so that they can have information on how to contact us, that would be great. Our website, again, is a work in progress, as is our program. Any program that the city does is always a work in progress, and we're always working to make improvements and make it better for the people that we serve. So we appreciate your feedback. We appreciate really constructive critiques in terms of ways that we can, do our best to serve you, understanding, the scope and responsibilities and authority that we have within the code. I want to thank our panel members. Tahiri had to leave early, but I want to thank her and Virginia. They are great partners with us at Sacramento Self-Help Housing and a really great resource for tenants overall. And to be really honest, a really great place to start, because sometimes tenants have issues that go beyond TPP. And if they are TPP issues, they'll make sure that they get to us. But if there's issues related to fair housing, if there's issues related to COVID, Sacramento, Self-Help and the Renters Helpline is a really great place for tenants to start. I want to thank Cheryl. She's done a really great job in terms of making sure that we understand how to interpret the code. And she's done a really great job in helping us to help tenants as we get everything in place. So again, even though our hearings aren't in place, we've been able to address and help a number of tenants because we've still been able to follow up and assist them. So I want to encourage folks not to wait until those policies and procedures are up. If you need assistance, contact us as soon as possible, and we're here to help. So again, thank you very much. Our email address and our contact information is there, and we look forward to working with you. Thanks. Bye.